profits.
Thank you, Chair. Thank you all for appearing today. Is it true that the Coal LSL annual report for the financial year 22-23 states that no compliance issues were reported to the Minister?
Senator, yes, I've got the annual report in front of me, and I think the compliance statement that you're referring to is specifically about obligations under the finance law. So the statement in the annual report says there have not been any significant directions given, policy orders or non-compliance issues reported to the Minister during the reporting period as per section 9A(1)(e) of the PGP Act, and that is specifically about the finance law.
Okay, so there are no compliance issues. I'd now like
in regard to the finance law.
And that would be stated there in regard to the finance law?
The Act, the 9A(1)(e) of the PGP Act is the finance law. Yes.
I'd now like to take you to page 101 of the Department of Education and Workplace Relations Annual Report 22-23, and I quote the following. Coal LSL has identified it may have mistakenly received levy payments from entities that do not meet the definition of employer for the purposes of the Coal Mining Industry Long Service Leave Administration Act 1992. If so, payment of amounts equivalent to the levy by the Department to Coal LSL in relation to those entities would likely have been made in contravention of Section 83 of the Constitution. That was 4 years after we raised governance, end of quote. That was 4 years after we raised serious governance issues with Coal LSL. Coal LSL has assured the Department that it is conducting further investigations to confirm how many entities, this is coming from Department of Employment and Workplace Relations, Coal LSL has assured the Department that it is conducting further investigations to confirm how many entities may have incorrectly paid levy and quantify any corresponding amounts that have been paid by the Commonwealth without a valid appropriation. What is the result of those investigations?
Senator, I might ask our General Manager Legal, Michael Dowser, to talk to what the issue is, because then the update on the investigation will certainly make more sense. So, thank you.
Yes, Michael Dowser. The issue that was that led to this issue was the definition of national system employer in the Fair Work Act. The definition in the Fair Work Act is a narrower definition that really confines a national system employer to a corporate entity, and then there is a broader definition that applies in certain circumstances, which brings in other employer entities. Coal LSL was administering the scheme on the basis, incorrectly, of that extended definition. That meant that there were some non-corporate entities that should not have been registered in the scheme. So the impacted non-corporate entities are a limited number of small businesses who had employees that were otherwise eligible participants in the scheme. So that's the nub of the issue that we've identified. An assessment was then made in relation to current and historical employers who have participated in the scheme, to identify whether there were any entities that were impacted and how and what further investigations might be required.
I might talk to what the investigation, which is still underway, Senator, but the updated report indicates we're looking at a maximum of 33 employers, and if I give the context of the quantum of employers that have transacted with the scheme, there's over 3,275 employers that have transacted in the scheme through that period. And we're also, based on the updated assessment, looking at a maximum of 463,000 in payroll levy. And if I put that into context, the scheme has received over $2.1 billion in payroll levy during that period. So not certainly acknowledge the issue has been identified, and we're working through how that needs to be remediated, but that is the updated figures. But through this investigation, it is still very possible that those numbers will reduce. We'll have a better understanding of that over the next month is that timeline of finalising the investigation.
So you can colour it, Ms Perks, as 463 is a lot, thousand is a lot less than $1 billion. You can characterise it that way. $463,000 is a lot of money. I can also characterise it by saying it's a breach of the Constitution. And you didn't pick it up. The Department of Employment and Workplace Relations did. So
if I
this is
just
significant
pick up
breaches.
from Mr Dows's categorisation of the issue, it's the definition of employer that has been applied. And I think the department updated this morning on how the issue came to light through their work that's been in progress. But it's, again, a narrower definition that was adopted from the organisation with the implementation of the Act.
One of the first things I did in 2019 in getting back into the Senate was raise Coal LSL, I think at the first Senate estimates that I attended. And we pointed out specifically that the governance was not appropriate. It's not up to standard. You then eventually had a review. Not a very thorough review, not a very comprehensive review, fairly narrow. That pointed out significant errors. So it's surprising that they're continuing. When were you notified by DEWR, Department of Employment and Workplace Relations, of the significant error?
We were in discussions with the department, made aware of the potential overcollection of levy. Again, in relation to the definition of employer that was being applied, we were made aware of that potential issue in April 2023.
Why was this issue not raised in the Coal LSL annual report?
The 2022-23 annual report or the 23-24 annual report, because it is identified in the 23-24 annual report. So, in the
it could have been. When does the report go to printing for 22-23?
The 2022-23 annual report.
Mm-hmm.
That was. It would have been tabled in Parliament in October.
So this was part of that financial year.
So why was it not reported in our annual report? A couple of reasons. Once we were made aware of the potential issue of overcollection of levy due to the definition of employer that was being applied, as an independent statutory agency, our action was to seek legal opinion on the definition, and then with that understand how, say, widespread or how contained the issue was within the scheme. Now that legal process or legal advice went over a few months to answer a number of legal questions, and it was through that period we were in continued discussion with the department on the progress of the assessment that was conducted again for the organisation. In regard to the annual report, again, the disclosure that you were referring to before is a disclosure of the finance law, and this is not a breach of the finance law.
I get that.
It wasn't included in our notes to the financial statements because through that period, at June 2023, we did not have a legal advice to inform us whether the issue was an issue for us, so we needed to receive our own legal advice on that, and then we needed to undertake the financial assessment to understand the quantum. So the annual report was signed by the board or approved by the board on the 7th September. The review that was being undertaken by our legal practitioners wasn't complete at that period.
Don't you think it would have been appropriate to put it in the report because it was signed in late September or mid-September, and just say it's not quantified, but we've had this detected?
We sought advice from many parties on that, Senator, and because the issue was still under investigation, it was advised it was not required to be included in that annual report.
Who advised you not to include it?
We had external advice, and we had discussions with the department and the ANAO about our obligations to report. So it was through that.
Discussions on that topic?
On that topic.
And which external advisor?
Who were our external legal advisors? We've had 2 advisors on this, one being Ashurst, the other one Herbert Smith Freehill. So
Thank you. How many entities paid levies when they should not have?
the numbers which I referred to before, numbers that we've received today, well, it is a maximum of 33. We expect that will reduce, and Michael, you might give some colour as to why that investigation may result in a number of those employers confirming that they are national system employers and will be eligible to remain in the scheme.
Yeah, we've conducted all the investigations we've been able to do based on information available to us or publicly available. The next stage of our investigation is direct engagement with those employers, whether historical or current. We have written to those employers. We've had some engagement with some employers who have come back to us, and we're waiting to hear from some others.
When could you give us a list of those employers?
We're currently working through the process of identification, so we're hoping to conclude that in the coming month.
So you don't know it's 33. As Perk said, it might be less. Could it be more?
No, 33 is the identified list. So there is a number of subcategories within that list where we have identified how that employer has been classified, and in relation to a number of them, we have to speak to the employer, the entity, and get some further information from them in terms of confirmation around their business arrangements.
Well, it wouldn't be appropriate for me to ask for them now. So when do you think you'll be completed the investigation?
I expect we'll be concluding. Well, we'll be hoping to conclude it in the next month. The only hesitation I have is there are some which it is really dependent on our ability to engage with them. So these are, in relation to a number of cases, they are employers who are no longer registered in the scheme. So we will have to see if they respond to our correspondence. If not, we'll have to make other forms of inquiry to run that issue to ground.
Were the employees working under labour hire or directly hired by the mining company or by their employer company?
The entities involved in this are mostly fairly small businesses. I think we've identified from the Australian Business Register that there might be 2 entities which would broadly fall into a description of labour hire, but they're very small businesses. So that is the only classification that we have. So there may be 2 of them, but we're talking about employers with very small number, less than a handful of employees.
Okay. And the total amount that was paid to Coal LSL, which should not have been paid, was $460,000?
That will be the maximum. We anticipate that may reduce further as the investigation concludes.
Over what period of time did this breach cover?
The definition of employer that has been adopted was with the implementation of the Amendment Act in 2011. So it's not. It's the definition that was applied in implementing that legislation.
So over 12 years.
What was the definition that at the time the organisation thought that was, well, through assessment, applied that definition of employer, and that is what has been utilised through the process of administering the fund through that period.
Can Coal LSL identify the individual company's money? Can you reconcile the misapplied money?
Yes, we reckon.
Did it just come back as a lump sum from DEWR?
So is the question, do we reconcile the employer money? Yes, we do daily reconciliations of the dollars, the levy that the employer pays. $460,000,
Is that broken down into components from each company?
Yes.
We have records for each employer as to
Okay.
how much they have paid, how much levy they have paid.
Okay. I remind you that we've exposed significant breaches in your governance and low standards in your governance. So, thank you. Oh, I might just ask one more question, a couple more questions. Your board is 50% CFMEU, 50% Minerals Council?
No, Senator, our board are 6 directors who are appointed by the Minister. They are nominated by different organisations as per our legislation. 2 of them, as per our legislation, 2 directors are nominees from the MEU.
Which
One
used
director
to be the mining division of the CFMEU, but it's now separate.
Yes, and 1 director is from a rotation of other unions. 1 director is a nominee from the New South Wales and Tasmanian companies. 1 other director is a nominee from the Queensland employers, and the 6th director is a nominee from the WA employers.
Okay, thank you. Thanks, Chair.